eliminated in the 73. So the Supreme Court making rules is really now completely up to the Supreme Court, which was not there till even 72. So there is a constitutional intent that the central focus of Article 191 is the Supreme Court really maintaining its internal autonomy on practice and procedure. And that is why the structure of 191, the central focus is on the Supreme Court making rules, but subject to law and constitution. So there can be a law that will be conditional, but because of the structure and the constitutional history, I would submit before your lordship that any act made by Parliament will be subject to 4 restrictions. And if your lordships and ladyship might kindly look at this.
Where are you reading these 4 restrictions from?
I'll come to if I may just read the 4 restrictions and then I'll come to this. First dot.
Mr. Siddique, if you see the preamble of this act, please read that.
Whereas Article 191 of the Constitution provides that subject to the Constitution and the law, the Supreme Court may make rules regulating the practice and procedure of the Supreme Court. Whereas Article 910A of the Constitution mandated right to fair trial and due process. Article 4 of the Constitution guarantees treatment in accordance with law. Article 25 of the Constitution prohibits discriminatory treatment, and right to appeal is a universal fundamental right of jurisprudence, and Islam guarantees right to appeal. Therefore, pursuant of Article 175(2), read with Article 191 of the Constitution, is being enacted.
So, my question to you is that do you think that Article 191 is not sufficient to meet the requirement of to establish procedure and practice of the Supreme Court?
I would say it is if the notion of appeal.
Whereas the same powers is being enjoyed by the High Court and the Federal Shariat Court under Article 202, 201 and 2 and Article 203J. What are those requirements which prompted the Parliament to constitute this act?
I would not like to, because a lot has been said as to why Parliament did it. To me, the central issue is whether Parliament had the constitutional authority to do it.
No, it is not disputed that the Parliament has no authority. But the question is, it is not done in the case of High Court, it is not done in the case of Federal Shariat Court. Why specifically the Supreme Court?
I'm not going to allege, go into the intention or malafides of Parliament.
We are not talking about that.
But the absence of the exercise of one constitutional power does not mean that an exercise of another constitutional power is unconstitutional. I mean, Parliament can tomorrow maybe exercise that also. वो उस वजह से तो नहीं हो सकता.
Same authority is being used by 2 other courts.
Yes.
But specifically it is done with the reference to the Supreme Court.
But exercising one kind of power is not barred by not exercising another kind of power. But the real issue is whether Parliament has this power and to what extent does it have
Just
this
to resolve this, Mr. Attorney General was repeatedly asked to bring the record of the legislation.
Maybe he can answer that. He is in a better position, sir. But I take your lordship's question.
There's one more question on the jurisdictional or jurisprudential plane. Basic principle is that an appellate forum or right of appeal is provided by the statute which confers the jurisdiction in the first place. Right? Right or wrong?
Not an absolute rule.
Okay. A statute doesn't provide an appeal. Another statute can provide on the same footing, it can provide an appeal. Or an amendment in the statute can provide an appeal. Here, the jurisdiction creating statute or instrument is the Constitution. if a right of appeal is to be provided, it has to be provided by the Constitution, not by sub-constitutional legislation. Because the effect of sub-constitutional legislation would be that you would be conferring the powers on a sub-constitutional instrument to provide such appeal. Is that doable jurisprudentially?
My lord, the position which I've stated before your lordship, and then I'll move on, I'll just state, because I'm very conscious of the fact that your lordships have taken a different position in the Ghulam Muhyiddin case. I will deal with that judgment when I come to that. But my position is, number one, if this appeal under this statute is unconstitutional, then the appeal under the law reforms ordinance is unconstitutional.
मैं सिर्फ प्रिंसिपल आपसे
मैं इसीलिए मैं प्रिंसिपल की बात,
if तो ठीक है, I mean उसका जवाब तो ये है, one, those matters are not before us. Two wrongs would not make.
And the appeal under the contempt of court ordinance has been upheld as constitutional by this court.
Yes.
That is also an intra-court appeal by a statute.
Under different circumstances and for different reasons.
जी.
मैं आपसे ये पूछ रहा हूँ कि ये jurisprudential जो principle है कि आप किसी और statute से which is not on the same plane as the original statute which conferred jurisdiction, आप right of appeal provide कर सकते हैं considering that it is a substantive right. So by sub-constitutional legislation, can you exercise the same powers as are envisaged in the Constitution, i.e. creating a right of appeal?
My lord, your lordship,
ignoring the fact that the instrument that creates the jurisdiction does not provide an appeal.
my lord, I think the instrument which creates the judicial forum in the first place is irrelevant. The issue is whether that particular provision has a bar to creating such an appeal through an ordinary statute, number one. Is there any bar in Article 185 that such intra-court appeals cannot be created? What I'm trying to understand, where does this bar come from?
From the language itself, subject
Which
to
language?
the constitution and the law. You see, you're relying on this language to say this is enabling and this gives competence. But there are other language where the constitution gives enabling powers to parliament and gives it competence. It's totally different language. So you are not creating any difference in that language. You are not saying that where the constitution is saying it may by law or it may by or under any law, which is a direct power that it is giving to the parliament, you are not making any distinction there. You are just saying read competence into the word law. The word law has been used over 400 times in the constitution. Do we read competence into every time the word law is used, or do we now start distinguishing yahan law ka kuch matlab hai, yahan law ka kuch aur matlab hai? That's why for interpretation you follow principles. So which principle are you following? And on what principle will we be able to say in the next case and the next case that this is the principle that we followed?
I think these are two separate questions. Your ladyship is still on the question of competence. Justice Ijaz has asked a question regarding procedure. These are two separate questions which should not be confused.
It's not separate, it's the same, and it goes back to Justice Shahid's question as to the manner in which any change in the jurisdiction given by the constitution
Where is the bar in the constitution which says that a constitutional forum created by the constitution bars a statutory remedy? Where is the bar?
Achha, can you cite any example where the jurisdiction creating statute does not provide an appeal and by way of subordinate legislation an appeal has been provided? Or to extend the example further, through another statute which is not on the same plane, a right of appeal has been created.
My lord, your lordship doesn't have to go to statute and rules. Your lordship just has to look at constitutional forums and intra-court appeals. Intra-court appeals.
That is precisely the point.
I think 270, Article 270 is answer to the question. where the constitution maker has upheld the jurisdiction of the parliament to enact by providing appeal to the Supreme Court. देखिए इसमें 270 में प्रोटेक्शन दे दी गई है.
No, but
इसका मतलब है उसको
the question is different.
प्लीज सर
The question is
ये है ना कि उसमें वो अपील की रेमेडी दे दी गई है, उस अपील की रेमेडी को अपहेल्ड कर दी.
My brethren, to let's one speak at a time.
where jurisdiction original jurisdiction has been created, conferred by the Constitution. Can sub-constitutional legislation interfere in that? And
Yes,
extend
if there
it
is no bar, and
No,
it cannot.
there is a bar. The bar is item 55,
And there is
which says express authorization. Now we have repeatedly asked you, where is the express authorization? 175(2) doesn't cut it.
Lord, I have
No, but Mr.
stated
Faisal,
170.
I mean, during the break, I went through the LPG Association against, and I stand wiser actually. I think 175 could grant that authorization.
Yes. So that is, I've stated that. I take your lordship's point. Maybe I will elaborate it when I come to your lordship, and I have the very difficult task
Okay.
to argue against the judgment.
Please proceed.
Please read to
With a very heavy heart. but
Article 270. Please read it.
जी जी जी. Then मैं move on so that I finish, sir. I know your lordships are temporary validation of certain laws.
As a side note, since you represent a political party, did anyone vote against this? Any political party vote against this law?
Sir,
If you don't know the answer, you can give it later.
Attorney General, मेरे ख्याल में Senate में PTI वालों
आपके clients बता सकेंगे ना?
नहीं, मेरे clients ने तो voted for them.
नहीं, naturally could.
Yes, I can ask them, sir. I didn't
Okay,
ask.
okay.
Sir, I'll move on to the next. But I'll come back to, and your lordship's question was.
270. ये आर्टिकल 270 आप पढ़ रहे थे.
जी, sorry. Majlis-e Shura may by law in the manner prescribed for legislation for a manner impact part 1 of the legislative list validate all proclamations, presidential orders, martial law regulations, martial law laws and laws made between 20th 5th of March 1169 and 19 day. Specific कोई section आप?
So law, the law reforms ordinance, the power of making law has been protected by Article 270 by the Constitution.
जी जी.
तो जब एक मर्तबा वो पावर कॉन्स्टिट्यूशन ने कहा कि ठीक है,
सर ये रेट्रोस्पेक्टिव प्रोटेक्शन है.
फर्दर के लिए भी है.
पोस्ट पेक्टो अप्रूवल थी भाई.
फर्दर भी उसको आज तक यूटिलाइज हो रही है पावर.
I take your point. I'll move on to the next point. ठीक है? Sir, there I think, and this is where I differ from Mr. Salahuddin Ahmed, I think there are two principles which have to be safeguarded in the context of the constitutional history of this provision, where slowly all executive role has been taken away. This has not happened in India. The executive role is still there in 145. But here, and the structure of the provision itself, where the dominant focus in the Supreme Court making rules. There are 4 limitations on the Parliament making laws regarding practice and procedure. Any act of Parliament under Article 191 Constitution 1973 will be subject to 4 restrictions, limitations. Firstly, the law has to be limited to practice and procedure. Secondly, the law cannot colonize or abrogate the primary role of the Supreme Court to frame rules. So if your lordships come to the conclusion, I don't support the view that Parliament can simply abolish the Supreme Court rules. That will destroy the complete autonomy of the Supreme Court. But if you're...
Can there be an implied repeal? Mr. Salahuddin took the position that they can be expressly repealed. Can there be an implied repeal?
There can be implied repeal, but does that amount to destroying the power of the Supreme Court framing rules? That has to be seen provision by
That can be
provision.
implied repeal. Why can't there be express repeal?
No, there can be express repeal in relation to specific provisions. The third.
So what you're saying is that if there is a rule is made and subsequently Parliament can undo that rule by
Yes.
making a law, so
Yes.
then the law will prevail.
Not in every circumstance.
What
And I'll
cir-
explain. when I read
How
the
does that then, how does one understand this second point of yours?
by the third
That it
point.
does not abrogate the role of the Supreme Court.
By the third point.
Which we are awaiting to hear.
Thirdly, no provision of such law can violate the constitutional provision of the independence of the judiciary. So your lordship has to look at every provision and see whether the repeal which has taken place of a particular provision impacts the independence of the judiciary or not. That is the method, and that is the thing which is being laid down in a Supreme Court judgment, will I judge side. The fourthly, no law can restrict jurisdiction or powers of the court on a harmonious reading of entries 55 and 58. So there is, these are the limitations on Parliament.
What about separation of powers? What about the constitutional principle of separation of powers? I find that missing over here. Why should that not be also a limitation?
My lord, I take that within the notion of the independence of the judiciary, at the heart.
That's a separate thing.
Learned Counsel.
They are two separate things.
Separation of powers is not restricted to the judiciary.
Yes.
What if the judiciary starts encroaching upon the powers of the legislature and
चले
executive?
पांचवा डाल दीजिए,
And
क्या
that
फर्क
is
पड़ता है?
how,
पांचवा डाल दें, क्या फर्क पड़ता है? कोई फर्क पड़ता है?
so I mean, there's a system of checks and balances
Yes,
as well.
yes.
So the parliament is empowered to legislate. And all that they have legislated is something which ensures access to justice.
That is what I will show when I come to provision by provision, that none of these provisions.
Can you elaborate a bit more on your second one? The court cannot colonize or abrogate the primary role of the Supreme Court to frame such.
My lord,
Kindly elaborate a bit more.
example of that is the Bas Kakar case. It's a classical example as to why the Supreme Court struck down that law. What in the Bas Kakar case, what the Contempt of Court Act 2012 did is that in terms of actual cases pending before a particular judge, in which that judge had taken cognizance of for example, a contempt on the face. In that, legislature interfered and that said that case will go before another judge.
That's not practice and procedure. That's not
No,
practice.
but
and
I'm saying that.
No, but Bas Kakar was decided in the context of Article 204.
No, I'm giving you an example.
But that was a different context. Give me an example of 191 when you say.
I'll give you an example.
Colonize or abrogate.
I'll give you an example. Let's take section 2. If there was any role.
आप जरा specific example नहीं, मुझे जरा पहले इस principle को जरा समझाइए.
नहीं, वही मैं principle.
आपकी limitation
मैं
क्या है?
example से principle को. Let's say that section 2 envisaged some kind of role of the executive in the constitution of the bench. That I would say would be a violation of 191 and the principle of the independence of the judiciary.
I would regard section 2. I mean section 3 actually.
Section 2 सर कमेटी जो बनती है उसमें एक कमेटी मेंबर चीफ
3 में है ना?
जी
3 में है?
2 में है ना, 3 में तो वो है ना सर मेंटेनेबिलिटी वाला सर.
Sorry, 2 में है. I would regard that as colonizing the.
I know your lordship comment about.
You used very interesting words.
Colonization.
Colonize. तो colonize.
बस ये लिटरेचर पढ़ के थोड़ी सी गलत
हो गया ना इसके अंदर. इसलिए मैं आपसे ये you're making an interesting point, but I want you on the plane of principle kindly to explain this point further.
Sir, this cannot be preemptively elaborated. This can only be understood through example because one doesn't know. Your lordship has to examine this provision by provision. That is why what I would be suggesting, that there is a debate between that we should open the door and not be afraid of it, and there is a suggestion about closing the door. I would say keep the door open, but there should be certain padlocks on it.
नहीं उसके अंदर.
No, but the other way is that keep the door open, but the watchdog is sitting.
Yes.
And watchdog ensures that nothing, fundamental rights are not violated. So all your 5 points could be summed up by saying that as long as that law doesn't violate the fundamental rights, which includes access to justice, independence of judiciary.
Siddique sab,
ये जो आपने बात की है second, ये आपको जो
Siddique
second है, how
sab.
does that square with the implied repeal? आपका ये जो second point है ना, secondly the law cannot colonize or abrogate. आपने अभी कहा कि implied repeal is possible.
Yes.
Kindly explain to me
Sir,
how. As a principle,
sorry.
principle की बात
Sorry.
करें. I mean, don't go into the nitty-gritty right now. वो तो आप आगे जाके करेंगे. मैं आपका principle समझ रहा हूँ. How does this square with the? You say there can't be express repeal, but how does this square with implied repeal?
No, sir, there can be express and implied. What Mr. Salahuddin argued that the Parliament can get rid of the entire Supreme Court rules. I'm not advocating that on a particular rule.
How do we identify the core that cannot be repealed?
Yes.
Mr. Faisal, the core would be that in case, Mr. Salahuddin might be correct, you see, they can strike down the entire set of rules provided they don't violate the independence of judiciary. Your argument is the same.
No.
Why stand on any provision? Suppose theoretically speaking, if you bring out a law which takes away all the rules that are there, but it doesn't affect the independence of judiciary, maybe enhances the independence, what's wrong?
My lord, I think what is underlining 191, and this is something which should be safeguarded at all circumstances, is at the heart of 191 is not the law made by Parliament, but the internal autonomy of the Supreme Court.
There has to be some
Siddique
principle.
साहब, my question please.
जी.
ये आर्टिकल 191 की जो लैंग्वेज है दैट स्टार्ट्स विथ सब्जेक्ट टू द लॉ इन द कॉन्स्टिट्यूशन. देयर आर वेरी फ्यू आर्टिकल्स ऑफ द कॉन्स्टिट्यूशन which starts with the word.
There are only three.
Only three. Yes. So does it means that because the constitution was framed in 1973 and the rules were framed in 1980, do you think that there is still a room is left for the improvement in the procedure with the passage of time? Like 184(3), whenever it has been used, ये पूरे मुल्क की बुनियादें हिला दी उसने जब भी इस्तेमाल हुए. तो do you think there is a room left for improvement in Article 184(3) or the procedure of the Supreme Court?
My lord, I think
Intentionally that has been done.
whatever amendments, and I'll take your ladyship through each of the amendments, whatever amendments have been done, I think that shows that reform is required under Article 184(3).
So can I just understand? आप ये कह रहे हैं कि 191 enables Parliament to make law.
Yes.
The principle to apply will be the independence of the judiciary. So the independence of the judiciary and the ability to make rules should be protected and preserved. But Parliament can make law with reference to practice and procedure.
Yes.
If they do make that law with reference to practice and procedure, so that's not undermining that principle of independence of the judiciary, but then we go into the provisions that
Yes.
they'll start making of practice and procedure, and so then see whether that meets the
Yes.
test. So then my question is that isn't the constitutional mandate the opposite? Isn't the constitutional mandate saying that the Supreme Court, to the extent of how it regulates practice and procedure, will do it itself, because that is in its own internal matter, and the only thing that's stopping the rule-making ability is anything expressly provided in the Constitution or by law. Like I said yesterday, limitation hai, court fee hai, is tarah ki cheezein hain which are procedure related, which you can't override through your rules. So ek system bana hua hai, uske andar they govern themselves internally. And it's interesting that in these 3 days of hearings, nobody has actually said to the Supreme Court that this is your rule-making power. What is stopping you today from making these rules? And why don't you exercise this power and call a full court meeting and actually exercise this power and bring whatever change you think today is acceptable? We're ready to argue this point and go into the delicacies of subject 2 and whether this is an expansion of jurisdiction or not. और आपके मुताबिक तो Supreme Court appeal की right भी दे सकता है. So problem किधर है?
If appeal is read into as procedure.
The point is कि अगर हमने independence of the judiciary को guard करना है तो where is the limit? कहाँ guard करें? कितना guard करें?
Your ladyship is
What principle should I follow?
Your ladyship is absolutely right. There's nothing stopping the Supreme Court from reforming itself, but a much more fundamental principle is involved.
Faisal, इस पे एक example, just to quote an example, in Germany and in South Africa, they have adopted the concept of the lawful judge, and I'm sure you must be aware of that. और उसके लिए उन्होंने elaborate criteria laid down किए हैं कि how the cases are fixed and before which judges they will be fixed. So there's no intervention by any master of the roster. It's all through, if the parliament tomorrow, in the interest of the litigants, legislates and on these lines, would they be competent to do that, and would that in any way, which protects the interest of the litigants, affect adversely the independence of judiciary?
Look, that is my precise point, that the issue is that does 191 create this delicate balance between preserving the internal autonomy of the court, but at the same time give a check and balance role to the legislature. That's the central point. That is why, regardless of whether there are internal reforms or not, the parliamentary role cannot be eliminated. But the parliamentary role, of course, has to come within the ambit of 191.
What would be the status of the Supreme Court in making rules in presence of this Act? Whether the Supreme Court can enhance power, make it committee from 3 to 5?
My lord, the first thing is, and this goes back, connecting both your questions, goes back that in terms of these rules, of course, there are certain rules of the Supreme Court right now which are in conflict with these rules. Like Section 2 of this Act is in conflict with Order 11. The review, the right to counsel, new counsel, is also in conflict with that. The Order, I think, 27 or 37.
Take a stand, Mr. Siddique.
Yes.
Take a stand. Don't beat about the bush.
Yes.
Direct question has been asked to you.
Yes.
If tomorrow the full court says that this committee consists of 5 members, can they do it? Or will the law, this act be the, Section 2 be the constraining, limiting power?
Or is there any restriction in the Act?
Give a straight answer.
Sir, after this Act, I don't think there can be enhancement in terms of Section 2.
So that means the Act trumps the Supreme Court.
As far, because it doesn't, unless and until your lordships can, someone can challenge Section 2 on the ground that having a 3-member committee violates fundamental rights or the independence of the judiciary. If you can't challenge that, then enhancement.
Are the rules binding on a bench? Whoever makes the rules of the Supreme Court, are they binding on a bench of the Supreme Court?
Yes, I think that's the law. The rules would be binding.
On the bench itself?
Yes. Unless that particular rule is suspended through a judicial order.
No, on a bench. A rule made through administrative power, is it binding on the Supreme Court exercising judicial power?
Delegated legislation which is made under Article 191, I think. So I think the rule would be binding, and there are numerous judgments.
We are talking about now constitutional matters here.
The question is...
Let me finish my chain of thought. There is a rule, whatever a rule says, a 3-member bench says that this rule, in our opinion, contravenes some fundamental right.
Yes.
Therefore, we will not strictly follow it. So surely it's not binding. Or you saying that the bench cannot pass such an order?
No. I'm saying unless, if your lordship declared the rules as ultra vires or a particular rules, of course they are not binding. But unless that is...
now we take the discussion a bit forward. If a bench of this court states that the rules under 184(3) have not been formulated in the Supreme Court Rules 1980, and therefore matters, till such rules are made, such matters should not be fixed for hearing, excluding habeas corpus matters. Can such a bench pass such an order?
If there is a constitutional basis for it,
I'm just asking you a thing, yes.
My lord,
184th at existing rules,
My lord.
there are, I'm not talking about hypotheticals, I'm talking about the rules 1980 as they are. A bench of this court says, since 184(3) petitions have been filed, and the mode and manner of how they should be heard has not been determined in the rules, can a bench pass such an order?
Yes, a bench can pass such an order if the bench can show.
And can the bench then say, let the full court make such rules?
On the first part of the question, the bench can pass such an order if such a restriction can be inferred or is present in Article 184.3, that 184.3 powers cannot be exercised until rules are made. If the bench holds that rules, unless rules are made.
I'm saying I'm saying it has done it. Now, either you say it's not permissible or it's permissible.
If a constitutional basis can be shown for
Yes.
that, I think, of course.
Okay.
I mean, if the rules are violative of the
When
Constitution,
there has been a case where a bench,
Yes, I know,
very
I'm aware of
bench of this court said that the rule should be enacted by the full court.
yes.
Now, if even exercising judicial power can be thwarted by saying no, then how do you get the rules made? It all depends now on the person of the Chief Justice. So please explain that to me. I mean, why are we just skirting the issue, hypotheticals? Why are we not coming to actual practical things which are happening in Pakistan where cases have been decided and sort of all over the place? Just take the bull by the horns and answer
Sir,
the
I'll
question.
come to that. I'll just cite two judgments.
नहीं, judgments किस आप ये I mean I just want to know the clarity on this issue.
मैं वो खत्म कर दूं, 1 मिनट दीजिएगा मुझे, सिर्फ 1 मिनट. There are two judgments, if your lordship, and I will not read them because I've already.
You can just add to that. Parliament can't make it. A judicial order cannot ask for these being made. So at the end of the day, it is all power vests in one individual called the Chief Justice of Pakistan, and that is
That
final.
is exactly my next point, but I'll just, because I just want to hurry. There are three judgments which your lordship may look at. At page 5, the first judgment, 92 SCMR 1208. This is where I draw this principle, where Justice Ajmal Mia,
12,
Sir, Afzalullah, sorry.
no, 120.
1202, where they say that we will not follow such statutory provisions and it will not override the rules which violate the independence of the judiciary. So this is where I draw that principle. There are two judgments.
But this judgment says that the rules will prevail
If,
over the statute.
yes, if the statute violates the independence of the judiciary, that's the criteria. But as a general principle, there are two judgments. One is from India, AIR 1964 Supreme Court 855. It's all written there, in which this conflict came before the Indian Supreme Court.
Where is it written in your booklet?
Page 5, top of
सर ये page 5 पे first 2 paragraph देखिएगा, और अगर ऊपर ही देखिएगा तो मैंने एक judgment दी है AIR 1964 Supreme Court 855, in which a conflict between a rule of the Indian Supreme Court as well as an act came, and they said the act.
I still don't know. You're going again around. Simple proposition is no. Sorry, you have to answer these questions. So all power vests in the Chief Justice, not in the full court, because full court is then dependent on whether the Chief Justice wants to call a full court meeting or not. The last full court meeting before the one that was called on 18th of September was about 4 years before. Prior to that, a lot of issues had accumulated which have still not been addressed through the full court meeting. So why are you hesitant in calling a spade a spade?
Sir, I'll answer that question now. My lord, the proposition which has been put forward, and this is one of my objections on the Ghulam Muhyiddin case.
फिर आप कैसे पे चले गए?
जी सर,
आप जवाब तो दे
मैं
दीजिए।
दे रहा हूँ
कभी आप इधर चले जाते हैं,
That is the first
नहीं,
case.
नहीं,
मैं जवाब दे रहा हूँ।
आपको मैंने एग्जांपल दे
मैं
दी है।
जवाब दे रहा हूँ, प्रिंसिपल स्टेट कर दूँ।
अरे चले, मैं आपको बता देता हूँ। अब चलें, हम इस कानून को उड़ा देते हैं, ठीक है? इस कानून को हमने उड़ा दिया, ऐसी मफरूजा दे रहा हूँ, ये कानून उड़ गया, ठीक है? अभी कोई रूल बनाना, मैं नहीं फुल कोर्ट मीटिंग करता हूँ, आप करेंगे क्या मुझे जरा बता दीजिए। नहीं, ये देखिए फैसल साहब, you are a highly acclaimed constitutional lawyer, so praising me or anyone else should not be a substitute for responding to a query. A constitutional query I'm asking you.
अभी यही क्वेरी आपका
आप फिर आप इस केस में ले जाएंगे गुलाम मोहयुद्दीन में?
अब मैं कोई केस साइट नहीं करूंगा, आपके सवाल का जवाब दे सर. The independence of the judiciary is not linked or is not threatened if the role of the Chief Justice is reduced. Now, that is not the principle. That I think
It took you a long time to say that.
Yes. No, I've written that here, sir.
You haven't said it.
That here. So this whole debate that the master of the roster must be the Chief Justice has been elevated to a constitutional principle. It is nowhere in any case law as a constitutional principle. As Mr. Salahuddin rightly pointed out, its whole basis is in terms of judicial history and in terms of statutory law. Ghulam Muhyiddin case is the first case which lays down that the Chief Justice, being the master of the roster, is linked with the independence of the judiciary. Your Lordship will find no case which makes this link. The link has always been with the independence of the judiciary linked with the Supreme Court itself, not with the particular...
Mr. Fasail Siddique, as far as the interpretation of judgments, whatever has been decided, you can give a lecture in a law school. Okay? Here the full court of Pakistan is sitting. We don't want to be given a lecture on precedents. We want to be enlightened by the understanding of the Constitution, which we keep saying is an organic thing, pulsating, evolving, catering to all sorts of situations. I mean, if you're just going to be stuck with the case law, then we should just take a lecture in some law school.
My answer is...
There is no constitutional input then coming.
My answer is that there is nothing in the Constitution...
The context of that, what you're citing from that judgment is legislative intervention. But the problem is not whether the Chief Justice is the master of the roster. That is not the context of what we are considering now. The context is, and let me therefore ask you the question which I have asked Mr. Salahuddin and Mr. Zaid Ibrahim.
I thought if we talk about which question comes first, now another question has been put on another question. Can you answer mine and we get on with it, and another question can be asked. So please don't mix up my question with other questions. You respond to my question. Let another question be asked after you've given an answer, or you can keep your answers safe till you finish your submissions.
My Lord,
I don't want my question to be added on to when I have a clear-cut question. Hopefully you've understood it. If you haven't, I've explained it further.
Yes, I've understood. If I may answer that question. Sir,
I thought you'd finished with your answer.
No, sir. Thank you. Sir, my answer is that reduce...
Never take my permission.
सर
डबल स्टैंडर्ड
नहीं सर आप मुझसे
सवाल आगे बढ़े
बड़े सवाल कम पूछे इसलिए मैं रिलैक्स हूँ
Are you taking the permission from...
चलिए आइए आगे बढ़िए
सर जी सर there is nothing in the Constitution which equates the Chief Justice with the Supreme Court. And what has this law done?
Why don't you say so? End of story. What's more to be said?
Sir, what is this law? सबने
sorry. Is this your answer?
नहीं आंसर हुआ है, बात तो कर लीजिए फैसल सिद्दीकी साहब. मैं आज मैंने सबसे कम सवाल पूछे.
सेक्शन 2 पे तो फिर आपका पे ले लूंगा.
सिद्दीकी साहब, मैंने आज सबसे कम सवाल पूछे. कम से कम यही राइट मास्टर ऑफ द रोस्टर को दे दीजिए प्लीज.
इसका जो कॉन्टेक्स्ट है ना वो बात का वो ये है जो मैंने सवाल उनसे किया था अपना सलाहुद्दीन साहब से, जाहिद इब्राहिम साहब से, दिस लॉ आप तो इसको बड़ा रिस्ट्रिक्टेड कर रहे हैं ना, बट व्हाट दिस लॉ डज इज इट मेक्स पार्लियामेंट द मास्टर ऑफ द रोस्टर फॉर द सुप्रीम कोर्ट ऑफ पाकिस्तान.
आप फैसल साहब नहीं कर रहे हैं
इसको ये असर इस सवाल का आप जवाब दीजिए.
माय लॉर्ड, देयर इज नथिंग इन
जवाब दीजिए पहले साहब के सवाल का.
देयर इज नथिंग इन दिस लॉ व्हिच मेक्स पार्लियामेंट द मास्टर. I mean, what has happened to the Chief Justice under Section 2? Has his role been eliminated? No. He is one of the members of the committee.
No, you're missing the point. You were present.
आप अपना जवाब तो सुन लेना आपका पहले. आप जवाब दीजिए, please.
Sir, in terms, because there is no constitutional provision which gives this elated position to the Chief Justice, and the Chief Justice is equated with the Supreme Court. For example, giving the power of the constitution of benches to three senior most judges, how does that violate the independence of the
I'll tell you.
आप बात तो कंप्लीट कर लें प्लीज.
Because it is that committee is the creation not of the full court, but
मैंने आपसे 2-3 बातें और भी पूछी थी. अगर चीफ जस्टिस फुल कोर्ट ना कॉल करे, अगर चीफ जस्टिस कुछ ना करे, तो फिर पार्लियामेंट ने कर लिया एक काम, ठीक है, मुझे करना चाहिए था, नहीं किया मैंने, तो किसी दूसरे ने कर दिया, तो अब वो कॉम्पिटेंस है. तो अगर मेरे ही में कॉम्पिटेंस है, चले वो बात भी मान लेते हैं, नहीं है तो फिर इसका मतलब एक लॉक जैम हो गया, क्योंकि चीफ जस्टिस ने कहा मैंने तो करना नहीं है किसी सूरत में, और मैं किसी और को भी नहीं करने दूंगा. तो बुनियादी बात तो यहीं आके ठहरती है ना. अब सादी बातों को सादे अल्फाज में बयान कर देना. इतने जजमेंट्स ये पहले इशू आया नहीं था सुप्रीम कोर्ट के पास, तो नया इशू है. तो आप ज़्यादा आइन को मद्देनज़र रखते हुए उसकी तशरीह कीजिए ना. अगर हम आइन की तशरीह सिर्फ जजमेंट से करने बैठें तो फिर हमें टेक्स्ट बुक उठा लेंगे, पढ़ लेंगे, उसमें वकीलों की ज़रूरत नहीं है, उसके कॉन्स्टिट्यूशनल लॉयर्स की भी ज़रूरत नहीं होगी. आप कहिएगा फलां आप पढ़ लीजिए बुक ऑन कॉन्स्टिट्यूशनल लॉ, आपको सारे जवाब मिल जाएंगे. नहीं, वहाँ जवाब नहीं मिलेंगे, क्योंकि अब जो चीज़ें हम देख रहे हैं वो पहले नहीं देखी गई थी, और हो सकता है पहले गलत देखी गई हों, ये भी मुमकिन है. तो अपना विजन खुला रखना चाहिए, बेशक वो मेरे खिलाफ बात हो या मेरे फेवर में हो. इधर तो मैं अपने फ़ायदे की बात नहीं कर रहा हूँ, जो आपको इसमें कोई रुकावट होना चाहिए कि आप चीफ जस्टिस के सामने खड़े हों और चीफ जस्टिस कह रहे हैं कि आप मेरे इख्तियारात में कमी ला रहे हो, तो आप हिचकिचाहट क्यों, आपकी तरफ से क्यों ये हिचकिचाहट
नहीं. मैंने तो क्लियरली स्टेट. एंड सर, वी शुड ऑल्सो नॉट फॉरगेट, योर लॉर्डशिप हैज मेंशन्ड अगेन एंड अगेन that here the legislature is being given the power to tell us how roster will be set. Who will constitute? Sir, the Supreme Court is the creation of the legislature.
No, we are the creation.
It is the creation of Parliament. That should
Constitution.
also not be
No,
forgotten.
we are the creation of the Constitution. Constitution says now we the
My
people
Lord,
of
but
Pakistan.
the people through their representatives.
Right, the people of Pakistan.
So, my Lord, this is
But
also
Mr.
legislation by
Siddique,
the people
Mr.
of Pakistan.
Siddique, the problem with the committee is not that there is a committee. If the full court had made the committee, that would be a different thing. The committee is the creature and creation of Parliament. It is the Parliament's will that is prevailing, and therefore at the plane of principle, for which you don't need any textbook.
मेरी इब्तदाई बात ये थी,
The problem is that Parliament becomes the master of the roster. This is my question to
मेरी
you.
इब्तदाई मेरी जो इब्तदाई बात थी वो ये थी कि अगर चीफ जस्टिस फुल कोर्ट मीटिंग कॉल ना करे, इब्तदाई बात थी, इब्तदाई, तो पार्लियामेंट की बात और फुल कोर्ट की बात तो रहती नहीं रहे ना. इब्तदाई बात का आपने उसको भी आपने नज़रअंदाज कर दिया. आपको पोजीशन ले लीजिए कोई.
Sir,
अब हमारे इंटरेस्ट से खिलाफ भी ले लेंगे पोजीशन, हम आपसे नाराज फिर भी
my
नहीं
Lord,
होंगे.
the point is issuing writs against a writ petition being issued, I mean a constitutional writ being issued against the Supreme Court itself. I think that requires some thought process. I mean, I can't answer that.
Will your
question
only
offhand.
remedy then be to file a writ petition against the Chief Justice to convene a meeting of the full court?
My Lord, I think it's
Or there is no remedy?
No. I think it's a question which requires serious consideration. I can't answer that question without seriously thinking about it. But because the Supreme Court did not do anything about these issues, that is why Parliament intervened.
Don't use the word Supreme Court. Please. Don't condemn all of us or any of us. The Chief Justice. If it is to be condemned, then point the finger to me, to the Chief Justice. Don't say the Supreme Court. Sometimes they use being interchangeably. I think they're very different. The Chief Justice, all 14 of my colleagues want to full court meeting. I don't want to call it. End of story. So are they all to be condemned equally with me?
Sir, we all have our sins, we all have our weaknesses.
देखिए ये बातें देखें, अगर आपको हम फिर आईनी बातें नहीं कीजिए ना, फिर असूली बातें ना करें. नहीं, फिर आप कहें कि जी हमें सबको खुश रखना है, एक गाड़ी चलाना है, हम सबको खुश रखते रखते बहुत सारे मसाइल खड़े हो जाते हैं. साफ बात करें, इसमें मुश्किल बात क्या है?
I have categorically stated the position.
इसमें एक बात ये बता दें कि क्या चीफ जस्टिस पाबंद है रूल के? क्या चीफ जस्टिस ने रूल के ताबे हल्फ उठाया या कॉन्स्टिट्यूशन और लॉ के ताबे हल्फ उठाया?
Sir,
तो चीफ जस्टिस की मर्जी हो, क्योंकि हल्फ नहीं लिया रूल के, इसलिए वो कहते मैं नहीं करता, जो करते हो कर लो.
I think the point is, your lordship knows the answer to that. I mean, there can't be a rule, there can't be a law which
Yeah, but
violates the
coming
constitution.
back to the question of interference in the independence of the judiciary, Section 2 and 3, they clearly vest the legislature with the power to constitute benches, to fix their number, and it makes it obligatory.
Let's take Section 2.
Obligatory to do so.
Let's say Section 2.
Fair enough.
Yes.
Now, if it makes obligatory to do so, it is actually dictating the committee how to act.
No,
Is
sir.
that not interference?
My lord,
Okay,
where
the
is the
committee
dictate?
says, okay, we don't follow
There are
Section
3 members, the Chief Justice who used to do it on its own, now does it along with his 2 senior colleagues. How can that be a violation of the independence of the judiciary?
What is wrong is that an entity which has nothing to do with the internal working of the Supreme Court is interfering.
My
And
lord,
when
if
it
you
is
eliminate...
interfering- When it is interfering, it is directly affecting the working of the court, and it gets a handle on the Supreme Court to pick and choose in what way it wants the matters to be heard.
My lord,
I think I will agree with Ijaz Sahab and I'll take it forward. And why don't you say, yes, it is interfering? Let's say, let's accept it for the sake of argument. Yes, it is interfering. Why don't you say, because the Chief Justice, you are not doing your job? Why can't you say that?
The very
Why? What's the hesitation in saying
No,
that?
there is no hesitation.
Because you are not fixing urgent cases. You are
There
fixing
should
cases at random, which may, I mean, I'm putting this allegation on myself. So let it not be understood that I'm putting it on somebody else. I'm fixing cases which I want to. I'll say Mr. Fasail Siddique's cases will not be fixed at all. Your practice goes for a 6. I'll say only cases of Mr. Abid Zubairi should be fixed, or whatever, whichever counsel should be fixed. Okay? You can't do anything, right? But so why don't you say, even if it is interference, it is good interference? Now the only question, back to question of my lord, जो जज साहब ने पूछा था पहले ही दिन से पूछ रहे हैं, और वही मेरे ख्याल में असल सवाल है, कॉम्पिटेंसी की वाली बात रह जाती है. अदरवाइज वाई यू हेसिटेटिंग? से आप लोग अपना काम सही करें तो यह ना लेजिस्लेशन की जरूरत बनती ना कुछ होता. अब जब लेजिस्लेशन बन गया, हम कहेंगे हम किसी से अकाउंटेबल नहीं है. हमारे पास जितने केसेस बढ़ते जाएं हम फैसला करें, ना केस एक केस सुने दिन में 50 केस सुने, हमारी मर्जी है. ठीक है? नहीं, सॉरी, इस तरीके से नई चीज़ें चल सकती हैं. हर अदारा को खुद एहतसाबी करना होगी सबसे पहले, इससे पहले कोई और उसकी एहतसाबी करे. तो पता नहीं, ये सीधी सीधी बात है. अब सीधी सादी बातें करें. अब केसेस में हमें उलझा करके घंटों चल रही है बहस. मतलब
frankly, when I look at Section 2, I see no violation of the independence of the judiciary. Yes, if that principle that under no circumstances Parliament can ever say anything about constitution or benches, then of course, then Section 2 goes. But I don't think if anyone can point out any element which violates the independence of the judiciary in terms of the committee. And it is a misnomer that the Chief Justice is no longer a part of the constitution of the bench. He's one of the members. His role has not been eliminated. I move on to the second one, which is the most difficult one, which is, and Justice Shahid had asked a very important question about framing rules. Framing rules. And I've dealt with that in my note. Your Lordship may have a look at that. But I'll move on to the second. But that's a very important question. There is no provision which says that rules should be framed. It says determining procedure, and I've tried to answer that in my note. Thank you, sir. Sir, 3. Now, it's a very important, this is the only provision which I would ask your Lordships to read down. This is the only provision.
Which is section?
Section 3, sir.
3.
What Section 3 does is that it says that there is this committee will at an initial stage look at whether these petitions are maintainable, whether the 2 conditions in Article 184(3) are present or not, Does it satisfy it or not? Now, this is clearly, as His Lordship Justice Mansoor has held, this is clearly a judicial adjudication. And this committee is really acting on the administrative side. It's obvious from the language of this provision. Now, there is nothing unusual, of course, about this initial, examination of these. The US Supreme Court does this. There is no hearing, there is no reasons at the leave granting stage. So the real problem is not that. The real problem is...
There is a problem here. With all due respect, your analogy is wrong. And I'll tell you why your analogy is wrong. The Supreme Court of the United States applies what is called the rule of 4.
Yes.
That out of the 9 judges,
yes,
at least 4 must agree to hear the case. That case goes to full hearing. But this scrutiny that you're talking about, that is not done by a committee of 3.
That is why I was going to add.
That is committee, because they all sit en banc.
No, sir, that is what I was saying. What is not unusual is no reasons and hearing is given.
No, that is not the problem with Section 3.
Sir, मैं वही तो बता रहा हूँ. Your Lordship is saying that when those 4 judges sit,
No, it's not the 4 judges. They have what are called conferences. I think every second Saturday they have a conference in which all 9 judges sit, and the cases are put up in conference. Any case that musters 4 votes out of the total 9.
Yes.
It's not a committee of 4 that sits. All 9 sit. The full court sits. What we would call the full court, that sits. And if 4 out of those...
and 5 when there is a grant of a stay order.
Sorry?
And 5 when there is a stay order. Yes.
आप तो सेक्शन 3 की बात कर रहे हैं ना?
जी.
तो अगर 4 जो हैं वो नहीं, 4 वोट उसको नहीं पढ़ते, cert, what they call cert denied, ठीक है? So it's not that there's a separate committee. Whatever they do, because they have their own, because they always sit en banc. यहाँ पे मसला क्या आ रहा है कि 3 जो what my learned colleague Justice Mansoor Ali Shah has stated in a very clear statement of principle, that the power of adjudication cannot be in the hands of any administrative committee. The context in which my learned colleague gave judgment was registrar, but as a matter of principle, with all due respect, it doesn't matter whether it's a committee, no matter how eminent or senior those judges are, the problem remains the same. So the US example, I'm sorry, is not...
Sir, I was giving it for a different reason. If your Lordship
आप ये भी बता दीजिए कि अगर हम देखें एक मुल्क से दूसरे मुल्क के एग्जांपल्स हम देते रहते हैं, हम ये भूल जाते हैं कि अमेरिकन सुप्रीम कोर्ट में 120 केस से सालाना फैसला होता है. अगर आप सुप्रीम कोर्ट, अगर आप इंग्लैंड की बात करें तो फिर नंबर्स हमें दें. हमारा सिस्टम बिल्कुल फ़र्क है. हमारे सिस्टम में हर कोई सुप्रीम कोर्ट जब तक नहीं आता खुश नहीं होता है, या CPLA में आएगा या सिविल अपील में आएगा. वहाँ ये सिस्टम है ही नहीं, बहुत कम केसेस होते हैं. तो अगर आप हर केस पे बैठ करके फुल कोर्ट ये तयन कर सकता है, ये वाले सुन लें ना सुन लें, तो आप ये सारी बातें फिर बताइए ना. अगर आपको एक एग्जाम्पल दूसरी जगह से लगाना है तो फिर अंग्रेजी में कहते हैं कंपेयर एप्पल्स विद एप्पल्स एंड पेयर्स विद पेयर्स. ये तो नहीं हो सकता कि आप एग्जाम्पल ले लें और उधर तो जी 120 केसेस हैं. अच्छा 120 केसेस में अगर पूरा अमेरिकन सुप्रीम कोर्ट बैठ के तयन भी कर ले तो कितना वक्त लगेगा? आप बैठ करके 56,000 केसेस को तयन कर लें, वो बात ही नहीं होगी, वो अलग बात है.
तो ज़्यादा होते हैं जी.
Let me clarify.
आप बताइए.
Cases run in several thousand.
जी several thousand.
Out of those only
जी
100 or
हमें देखिए जो चीज़ हमारे पास है नहीं, मुझे नहीं पता. अगर आप कोई चीज़ फाइल करें हम पढ़ लेंगे
Sir,
उसको.
the only reason I cited that, I agree with you.
Supreme Court की Wikipedia
I agree. I actually agree with you. What I'm citing it, the problem with the provision is not that reasons are not given or there is no hearing. The problem is this maintainability adjudication cannot take place on the administrative side by even a committee.
आप रिपीट कर रहे हैं बार-बार.
देखिए इसका हल क्या है? इसका हल क्या है?
रीड डाउन करें.
इसको रीड डाउन कर दें और रीड डाउन इस तरह करें कि the scrutiny may take place. But whatever the petitions are should be put up with the scrutiny report to a judicial bench. This is the way to say. ये सिर्फ ये आपको करना है और not maintainable.
वकील साहब, आपने सेक्शन 3 पढ़ा नहीं है
जी.
उसका आखिरी पार्ट पढ़ें.
जी.
आप जो रिपोर्ट की बात रीड डाउन करने की कर रहे हैं जी, इस सेक्शन का आखिरी पार्ट पढ़ें.
Sir, I'll read the whole. Any matter invoking exercise of original jurisdiction under clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under Section 2 for examination, and if the committee is of the view that a question of public importance with reference to enforcement of any of the fundamental rights conferred by Chapter 1 or Part 2 of the Constitution involved, it shall constitute a bench comprising not less than 3 judges of the Supreme Court, which shall also include the members of the committee for adjudication of the matter.
आप जो बात कर रहे हैं ना, अगर कमेटी हो तो ये आखिरी words जो हैं, they would need to be eliminated.
No,
obviously,
no.
Committee, so the three member committee वो इसको scrutinize करे.
Yes.
Say not maintainable, puts it up before a 5-member judge, of which
No, why 5-member bench? 3-member bench? अभी सिर्फ ये वो केसेस पुट अप करेंगे
से मेंटेनेबल फिर
नहीं. यस, ये तो हर सर चेंबर में अपील जाती है, इनिशियली एक डिसाइड होता है मेंटेनेबिलिटी का इशू. दैट डजंट बार द कोर्ट फ्रॉम डिसाइडिंग द मेंटेनेबिलिटी क्वेश्चन व्हेन इट इज पुट बिफोर अ जुडिशियल बेंच.
सवाल जो उन्होंने पूछा है वो ये है कि अगर फर्ज करें ये कह दें कि नॉट मेंटेनेबल,
Yes.
then what would be the remedy available to the
No.
aggrieved person?
अगर वो कह देते हैं नॉट मेंटेनेबल, आई वुड से दिस इज व्हाट योर लॉर्डशिप हैज. इसमें सिर्फ ये कहा गया है कि जो मेंटेनेबल होगा वो बेंच के पास
नहीं
जाएगा.
नहीं, अगर फर्ज करें वो नेगेटिव में उसका वो
आप
कर
जो
दें,
read
तो
down
फिर भी बेंच के ऊपर पास जाएगा सर.
नहीं जाएगा. कहाँ लिखा हुआ है?
सर यही तो रीड इन करना है, यही रीड इन करना
बात सुने, उसमें ये भी लिखा हुआ
यही
है
रीड इन करना है.
which may include members of the committee.
Yes.
So notionally, it can go before the same judge
Yes.
again.
Yes.
And this time you would expect them to hold that it is maintainable.
सर फिर तो रिव्यू जुरिस्डिक्शन भी खत्म कर देनी चाहिए.
नहीं, मगर दूसरी बात है कि अगर ये
I
कानून
think there's a simple
अगर
solution to this.
देखिए उसको सॉल्यूशंस ढूंढने से पहले जो मौजूदा निज़ाम है इस कानून को एक तरफ रख दीजिए. तो इस मौजूदा निज़ाम में कैसे होता है? देखिए साहब, इधर भी थोड़ी सी तवज्जो दे दें कभी कभी.
नहीं सर, आप प्लीज शर्मिंदा पे शर्मिंदा.
नहीं तो आप देख कहीं और रहे हैं. तो ज़रा ये देख लीजिए, मौजूदा निज़ाम में अगर ये एक्ट तसव्वुर कर लें कि नहीं है बना, अब 184 की आई थिंग, अब तो वो ब्रांच में लिखेगा नॉट मेंटेनेबल, यही लिखेगा ना, या पुटअप कर देगा कोर्ट में या लिख देगा, फिर उसकी करेंगे चेंबर अपील. ठीक है, फिर जज कह देगा द ऑब्जेक्शंस आर सस्टेन्ड और ओवर रूल्ड. तो ये कहना कि ये जो निज़ाम आया है ये मौजूदा निज़ाम से ख़राब है तो एक अलग बात है.
नहीं, ये मौजूदा निज़ाम से बहुत बड़ी इम्प्रूवमेंट
अभी तो
है.
वो इख्तियार सारा उसके पास बैठा हुआ है, वो रजिस्ट्रार खुद भी नहीं कर रहा है, वो कोई सब डेलीगेटेड पावर एक्सरसाइज कर रहा है जो पता नहीं जो पिटिशन एंटरटेन कर रहा है. ठीक है, और वो बहुत से लोग शायद अपील भी ना करें, वो भी चेंबर अपील है, वो अगेन वही जज अगर चेंबर अपील में उसने सपोज कह दिया, वो कल बेंच में बैठ सकते हैं क्योंकि वो एक और चीज तरह की नजर से देख रहे हैं, अब बेंच में बैठ के दूसरी नजर से देख रहे हैं.
All cases which go through scrutiny should be put up before a judicial bench. What is the issue?
फैसल साहब ये बताइए,
What is the issue?
फैसल साहब जी ये बताइए, क्या जो इसकी डिफिकल्टीज यहाँ पे अभी हाईलाइट हो रही हैं, आर वी empowered under Article 191 to amend our rules accordingly and remove these difficulties? The power vests in us.
बिल्कुल.
So there, I don't see any
I don't
difficulty
I
or
don't
problem in
see
this.
how this provision is a threat to the independent. If all cases after scrutiny are put before a judicial bench.
Mr. Faisal, यहाँ पे हमें एक चीज और क्लैरिफाई कर दीजिए. 191 के तहत अगर फुल कोर्ट की मीटिंग कॉल करनी है तो किसने कॉल करनी है? Where it is written? Who will call the full court meeting?
So that is to be called by the Chief Justice.
It says the committee now.
Where it is written?
So this is the practice.
Committee will, including meetings and constitution of benches with the committee now.
Sir, वो full court meeting की बात कर रहे हैं, not the constitution of benches.
तो इसका मतलब
Sir, that is a practice. Your lordship is.
नहीं तो practice तो यही है ना कि
want to
that
amend
is
the
to be done
rules,
by
then
the
other
Chief
judges
Justice.
can call the meeting and amend the rules,
Yes.
and they do it.
Sorry?
If the Chief Justice doesn't want to amend the rules, then The other judges can call the meeting and amend the rules.
نہیں اس میں نہیں ہے.
Sir, these are very difficult questions which I need to really
آپ
think
کے
about.
سامنے ایک سچویشن چیف صاحب نے رکھی ہے
جی بالکل.
کہ اگر میں کیس فکس نہیں کرتا تو کیا ریمیڈی ہوگی آپ
Sir,
کے پاس.
مجھے ان سوالوں
The other judges would be silent spectators.
یہی ہے نا.
Can they call the convene the
یہ جو
meeting and amend the rules?
conflicts ہے within judges, ان کے بارے میں
اس کا جواب اسی لیجسلیشن میں دیا ہوا ہے. 2 سبسیکشن 2 پڑھے.
وہ کمیٹی کی میٹنگ ہے.
پھر وہ کمیٹی وہ کانسٹیٹیوشن آف بینچز
اس سے اوپر جب شروع کریں گے تو اس میں کون سی چیز رہ گئی ہے؟ ایوری کاز اپیل میٹر
وہ ایڈمنسٹریٹو سائڈ پہ
سب کچھ ہو جائے گا.
نہیں سر, یہ جوڈیشل کانسٹیٹیوشن آف بینچز ہیں, ان کا سوال
وہ سوال یہ ہے کہ اس میں کون سی چیز ہے جو اس میں اومٹ کی گئی ہے.
Sir, I wouldn't like to read matter as involving full court meetings.
یہ پہلی دفعہ سچویشن ارائز ہو رہی ہے جیسے ابھی پوائنٹ آؤٹ کیا گیا, تو اس کو ہم ایگزامن کر رہے ہیں, تو وی نیڈ یور اسسٹنس. واٹ از یور ویو پوائنٹ؟
فل کورٹ کال کرنے کا تو ویسے بھی رولز میں تو کوئی پروویژن نہیں ہے.
کوئی پروویژن نہیں,
بالکل نہیں.
This is practice.
دیکھیے صاحب
جی
لائٹر نوٹ, اتنے پیسے کلائنٹ نے نہیں دیے.
اب میں اپنے آپ کو شرمندہ نہیں کرنا چاہ رہا. These are very difficult questions, my lord. I really have to think about that these conflict within judges, how are those to be resolved, whether writs are to be issued, what are the other mechanisms. These have no easy answers. مجھے اس کیس کے اوپر سوچتے ہوئے اتنے ہفتے لگ گئے. I think what your lordships are taking will take me 6 months to really think about.
Mr. Siddique, ہم نے سنا ہے کہ you are a sportsman. کبھی کوئی ٹیم ایسی دیکھی ہے جس کے 3 کپتان اور وہ جیتی ہو؟
And Mr. Siddique, you can ask for the in-camera proceedings.
ویسے صدیقی صاحب اسپورٹس سے میرا بھی تعلق ہے, کپتان اور وائس کپتان ضرور ہوتے ہیں.
سر سپریم کورٹ میں ہوپفلی کپتان نہیں ہونا چاہیے. سر لیٹس موو آن. آئی جسٹ رننگ تھرو.
صدیقی صاحب کیپٹن ایک ہی اچھا لگتا ہے.
Sir, Section 4, sir. Section 4 says that whenever an interpretation of constitutional provision is involved, a bench not be less than 5. I think
that is again a dictation.
My lord, I mean it is.
Shall not be.
My lord, it's.
Why can't the committee say, well, this is an important matter?
But how will that affect? If there is a substantial question of law,
I don't have a question of how will it affect. All along my question is, who is saying it? Who is constitutionally competent to lay down this principle? If this rule can be laid down by the court in its rules, and
if Parliament has legislative,
in terms of its rule-making powers under 191.
Sir, if Parliament has legislative power, then your lordship has to see whether this rule violates the principle.
That's a big if.
Yes. If Parliament has no legislative power, then this law goes, this provision goes. Otherwise, one looks at this provision.
Mr. Faisal, according to you, the Parliament has the legislative.
Yes. And the only issue.
No, move on. According to you, Parliament has the power. We will decide whether Parliament has power or not. Now move on.
ये clarity इसमें सिर्फ ये.
If the Parliament, if we come to the conclusion that yes, of course, Parliament has the power to make a law, then in law the Parliament may use the word may or may use the word shall.
But even Parliament cannot make a law which will destroy the power of the Supreme Court to make rules and violates the independence of the court.
Okay, so tomorrow the Supreme Court full court says, well, we think 5 judges are not enough, or 5 judges are too much, we want to make it 3. Can they do it?
No. In terms
they
of
cannot,
this, in the presence of this law, they cannot. Yes.
So that means a power of this court has been trumped by a legislative instrument.
Sir,
چلے آگے بڑھے نا یہ آپ.
The question should be what fundamental rights or independence of the judiciary has been violated. The only thing was that it's a bit badly drafted. The term is actually a substantial question of law involving interpretation. یہی ٹرم یوز ہوا ہے آرٹیکل 185(2)(f) میں.
چلیے دیکھیں کوئی نئی بات کریں تو پھر دوسروں کو سن لیں.
ایک سیکنڈ, ایک آپ نے کہہ دیا 3 کو ریڈ ڈاؤن کر دیں,
صرف 3 کو.
ٹھیک ہے. 4 is badly drafted. अभी हम 4 पे आए हैं, अभी आगे 5
Sir,
पे you have an uphill task.
No, but sir, the point is, has ever a law been struck down because of bad drafting?
No.
Or being
No.
impractical?
A law can be struck down on various grounds.
Yes.
One of which is it is vague, it is unclear, it is
Not on
beyond,
bad drafting.
It is beyond legislative
Yes,
competence.
but not on bad drafting. अब एक criminal lawyer ने ये law बनाया तो वो constitutional problems तो कुछ होंगी sir. Sir, section 5 sir.
Is that a confession?
You are saying it. You are saying it behind his back.
Sir, मुझे तो यही समझ में आता है.
नहीं ये ना
अब now I come to the main question, which is this problem of a full court and there being no appeal, and the problem that if there are 8 or more if there are 9 judges, there would be no appeal.
नहीं, मगर इससे पहले तो आप ये तो आपने गिवन कर लिया प्रॉब्लम है. देखिए ये ऐसे ना अप्रोच.
नहीं
आप देखिए मौजूदा सूरत हाल में बेहतरती खराब थी. ये तो कहना ये प्रॉब्लम है कि फुल कोर्ट हो गया तो अपील नहीं है, तो फिर आप इस कानून
मैं इसका जवाब दे रहा हूँ.
नहीं, जवाब नहीं होगा. ये क्वेश्चन हो ही नहीं सकता है. मैं बता रहा हूँ क्यों नहीं हो सकता है. सवाल इसलिए नहीं उठेगा.
सवाल तो वैलिड है.
जरा सुन तो लीजिए ना, आप समझने की कोशिश कीजिए ना. मौजूदा सिस्टम क्या है, इस कानून को एक तरफ रख दीजिए. आप जरा तवज्जो दीजिए.
जी.
मौजूदा सिस्टम ये कि इस कानून को 1 मिनट एक तरफ रख दीजिए. जी, अब कौन सी अपील है ही नहीं ना. तो अब आप कह रहे हैं ये कानून जो आया है 99% खामियों और परपोर्टेड खामियों को दूर करने के लिए, वो इस लिहाज से बुरा है क्योंकि वो 1% केसेस जिसमें फुल कोर्ट होगा कोई अपील नहीं है. तो पहले तो फिर अगर आपका ये बात मान ली जाए तो आप फिर तो आप ये कह रहे हैं, आपकी बात में ये इम्प्लाइड है कि ये कानून दुरुस्त है. अब आप 1% के लिए भी अपील प्रोवाइड कर दें तो फिर ये निकलेगा. या तो आप कहेंगे कि जी 99% तो मसला सॉल्व हो गया, 1% कराएंगे.
मैं यही बात कहूँगा कि the mere fact that there isn't an appeal in certain category of cases would not make the law unconstitutional. And I'll tell you why.
There may most certainly be a difference of opinion. One person can think that this is not relevant, but I think that it is very relevant, because when the law gives a right of appeal and the committee has the option of taking that right of appeal away, then it is relevant to the person whose right of appeal has been taken away. If we recognize appeals as being substantive, then that so-called arbitrariness that is being controlled, I don't see how it's being controlled. Because किसी को right मिलेगा, किसी को right नहीं मिलेगा. Again the question will be ये कैसे decide होगा. Again we'll go looking and hunting for principles कि कौन सा principle apply करें. So on the face of it, it means that either you can't ever constitute a full bench, you can't constitute a bench which is more than 7 or 8 members, that's it. You're not allowed to do that because Parliament has said appeal होनी चाहिए. और अपील होनी चाहिए का मतलब है that every order of the Supreme Court under 183 has to have a right of appeal. It doesn't mean that I have the option to choose कि अब full court बैठ गया तो सब अब कोई फ़र्क नहीं पड़ता क्योंकि सब ने केस सुन लिया. Right of appeal is a right of appeal, which we've heard at length yesterday, how we recognize that right of appeal, how Islam recognizes that right of appeal. So यहाँ कैसे हम वो right ले लेंगे वापस and कहेंगे नहीं यहाँ नहीं है क्योंकि हम सब बैठ गए.
Mr. Faisal, if you look at to me it appears to be an intra-court appeal.
Yes.
So at the High Court, if the larger bench is constituted, there's
Yes.
no intra-court appeal.
Sir,
so if there's a larger bench, there's no appeal.
There are 3 restrictions on an appeal from a single judge in an inter-court appeal.
अच्छा ये इसमें एक और बात अगर आप मद्देनजर रखें, हम अगेन realm of conjecture
सिंगल बेंच इस वजह से जब डीबी सुनती है या 3 जज सुनते हैं तो इसलिए उसकी अपील नहीं जाती. लॉ रिफॉर्म itself provides an answer. The appeal provides where a single judge decides the question.
जी मैं
1 मिनट आप सर जी
देखिए हम कंजेक्चर समाज से भी बात कर सकते हैं. अब आप मुझे बताइए आखिरी इस फुल कोर्ट से पहले कौन सी फुल कोर्ट थी?
I think 2015 सर.
कितने साल गुजरे?
जी 8 साल हो गए.
तो हम उस केस के लिए सिर्फ फिक्रमंद हैं या हम फ्यूचर के लिए फिक्रमंद हैं? 2 बातें हो सकती हैं ना. एक तो पिछले के लिए हम फिक्रमंद हैं कि वो केस में वो जो 21वीं अमेंडमेंट टू द कॉन्स्टिट्यूशन है वो एक राइट ऑफ अपील सलब हो गई और वो नहीं हो सकती है. ठीक है, ये एक मफरूज़ा हो सकता है, ठीक है। दूसरा है कि नहीं, हम पिछले के लिए फ़िक्रमंद हैं तो हम फ्यूचर के लिए फ़िक्रमंद। फ्यूचर की जब बात आएगी, जब एक्चुअल बात आएगी हमारे सामने, फिर हम अगर आप हमें इतना रिस्पेक्ट देते हैं कि हम आपस में कुछ समझ लेंगे इसको, हमें ये तो नहीं बताना है कि फ्यूचर में क्या होगा। हमारे सामने जो मसला आता है, और हमेशा ही कहा गया है, उसी मसले को हल करो जो आपके सामने आ जाए। अब क्या मसला होगा आइंदा, हो सकता है कभी फुल कोर्ट होना, हो सकता हो जाए, तो जब वो मसला आएगा फिर आपको सुनेंगे कि फुल कोर्ट बैठना चाहिए, 7 मेंबर बैठना चाहिए, 10 मेंबर बैठना चाहिए, वो सारी बातें इशू खड़े हो जाएंगे। अभी तो फुल कोर्ट एक ही बैठी थी, मुझे जहाँ तक याद है, आपकी बात सही है, 2015 में 21वीं अमेंडमेंट की बात, उसके बाद तो फुल कोर्ट नहीं बैठी, तो ये आई है दूसरी दफा फुल कोर्ट तारीख में।
My answer to the question, this is one way of
When legislation is framed, the legislators are supposed to look at all eventualities and try as far as possible to cater for them. Now, it is so obvious that there is this defect in this law. Was it debated? Was it thought about? Was there a thought process? And thereafter, it was drafted, keeping in mind कि जी फुल अगर कोर्ट हियरिंग करेगा तो उसकी अपील नहीं होगी, and if it was thought about it, why was it not mentioned in the
my response would be,
so the obvious conclusion is that there is a flaw, and
there is no flaw.
Is so apparent
there is no
that
flaw.
Everybody can see it.
No, there is no flaw. It's a self-contradictory question. When you say that there should be an appeal in the full court, no legislature in the world can provide an appeal.
Nobody's
to the Supreme
saying that there should be an
There
appeal.
can never be an appeal to the Supreme
You
Court.
have actually
There can
misunderstood.
never. It's a
No, Mr. Siddique,
self-contradictory
the question is not whether there should be an appeal in the full
question.
court. The question is simply that how will this right of appeal be exercised if you cannot constitute a larger bench because you have been stopped from doing so, which means that when a full court, if the committee decides, or as in this case, where a full court is sitting, if this law is upheld, that there is no right of appeal. So the question is simply this,
There
that
can never be a
aapne
right of appeal.
block kar diya na right of appeal. What is the point of giving that right?
कोई legislature दुनिया का अपील दे ही नहीं सकता. 50 जज हो जाए.
There is another aspect to it.
But I come to the 9 judges thing.
Actually, there is no answer to this question.
No,
so
there is an
we
answer.
go around and put a full stop to it. कि जब full court में हम बैठ के, यानी कि हमने जब decide कर लिया full court, तो then there's no right
आप
of
ऐसी
appeal.
चीज की deprivation किस तरह मांग सकती है जो हो ही नहीं सकती.
You have deprived someone something that the lawmaker thought was essential.
I think it's
That's
not
what you've
it's
done.
not a problem at all. It's not a problem at all.
But मैं कहता हूँ, अच्छा ये 9 मेंबर की
साहब ये देखिए
एक सेकंड,
सेक्शन
दूसरी
5
बात
में
ये
लिखा हुआ है,
है
सेक्शन 5 पढ़
ये
लीजिए,
जो पावर है
राइट ऑफ अपील का,
आपने तीन जजेस की कमेटी को दे दिया कि किस में वो राइट ऑफ अपील देंगे और किस में नहीं देंगे.
सर मैं उसका जवाब दे
Is that correct?
मैं उसका जवाब दे देता हूँ. देखिए, full court I don't think even a right of appeal can be demanded. Now the issue is that in cases.
So no, where does the law say that?
Sir, it is an impossibility. You cannot provide 50 जज भी हो जाए किसी कोर्ट की, आप फुल कोर्ट की अपील किस तरह
लार्जर बेंच बन नहीं सकती ना.
देखिए सदीकी साहब
That is precisely the point. That it has not even.
सदीकी साहब जरा देखिए इसमें
It has not even been debated.
अपील में ये बताया गया है कि the appeal shall be heard by the larger bench. ठीक, लार्जर बेंच के नंबर नहीं बताए कि क्या एक जज मजीद बैठ के लार्जर बेंच होगा, 2 जज मजीद
लार्जर बेंच तो हो ही नहीं सकती ना. इसके अंदर जब फुल कोर्ट हो गया तो देयर इज नो लार्जर बेंच फॉर अपील.
सर सुन ले लार्जर बेंच की प्रोविजन भी हो सकती है अगर ऐसी सिचुएशन आए.
It's a matter of interpretation by the court and it's sort
ये
of
हम रूल्स में देख सकते हैं. इवन कॉन्स्टिट्यूशन हमें ये इजाजत देता है, whenever there is need, as per the constitution, a judge of any high court can be called for a particular case. तो लार्जर बेंच बनाने की,
So इसमें भी हम रीड इन कर
going on too
लेते
much
हैं. ये
on-
इसमें भी हम रीड इन कर लेते हैं कि ऐसे करना ऐसे करना.
ये
So आप
read
2
in
प्रोविजंस हो गए, रीड इन एक होगी, बैडली ड्राफ्टेड, ऐसे ही करते हैं.
रूल्स में कर सकते हैं.
Rules cannot read down something which the legislature could never do.
Mr. Siddique, आप रिडंडेंसी तो इस अपील में रिडंडेंसी तो नहीं एट्रीब्यूट कर सकते ना. आपने अपील प्रोवाइड करनी है
नहीं,
एंड इन ऑर्डर टू अवॉइड रिडंडेंसी अच्छा
नहीं करनी, बट लार्जर बेंच का मतलब ये फुल कोर्ट के ऊपर अपील नहीं होगी।
आगे बढ़े, आपका हमने मौके सुन लिया।
होल्ड हो गया, लेट मी कंप्लीट। In order to preserve that right, in order to preserve the right of appeal, in essence, you can never constitute a full court.
Sir, because full court पे अपील हो ही नहीं सकती, तो you can always constitute
तो आप उसको
In that case, there'll be no appeal.
flipping the argument
आगे बढ़े ना
आगे
फिर।
चलिए।
सर,
आपका मौके सुन लिया, हमने कहा नहीं हो सकती, चलिए अगले बात बताएं।
सेक्शन 2 रेट्रोस्पेक्टिविटी का इशू था, ये अपील दे दी गई है रेट्रोस्पेक्टिवली। सर, there are two principles which will radically reduce the right which has been given. The first was pointed out by Justice Athar. This is an appeal against orders passed under Article 184(3). If an order has been passed after that under review jurisdiction, the appeal will not lie. These are not orders which, that's the first thing.
Then एक second, does the law say this or this is your interpretation of the law?
Sir, 184(3) के orders है ना, अगर आपने review file कर दिया, उस पे review का order आ गया।
188
अगर किसी को अभी किसी का review pending है and he wants to really have the right of appeal, he has to withdraw his review.
I mean, you see, there is no cut-off date of filing appeal. There is open-ended.
There is a cut-off date for filing appeal.
Mr. Siddique,
जो
वो सिचुएशन आएगा हम देख लेंगे ना।
सर सेकंड प्रिंसिपल मैं बता दूं, सेकंड प्रिंसिपल।
अरे आप मफरूजों पे जा रहे हैं, वो what may or may not happen, but just tell us। देखिए, surely it boils down to one thing. Some of us think the law should be struck down because the right of appeal is not being extended to what will happen to the scenario when there's a full court. ठीक है, others think it doesn't matter. Fine. I'm just saying, can you strike down a law that it creates a right of appeal, but it is to be struck down only because in one given scenario there is no right of appeal?
And sir, no law can be struck down on the argument of floodgates. No law can
अब आगे बढ़े ना, आगे बढ़े।
The second restriction is that in every retrospective law, your lordships have said that this retrospectivity will never apply to closed and past transactions, और वो vested rights have accrued. Sir, 184(3) के 1% से कम केसेस होते हैं।
आप बात सुने,
आपने रिव्यू निकाल दिया, आपने वेस्टेड राइट निकाल दी, क्लोज्ड एंड पास ट्रांजैक्शन, कितने केस बच गए?
कल ये आर्ग्यूमेंट हुआ कि इसको आप रीड डाउन कर लें एंड इट एक्चुअली मींस 30 days, within 30 days of filing of the promulgation of this act, जो decisions आए हैं या before उसके आए हैं within 30 days, तब से वो limitation start होगी, लेकिन 1973 से या 1974 से नहीं होगी। ये भी आर्गुमेंट आया और हमने नोट किया।
Sir, I'm not arguing. There is nothing wrong with this provision if these two principles are.
All right.
I'll move on.
Mr. Siddique, 184(3) is a constitutional provision,
जी, sir.
and it is original jurisdiction.
जी, sir.
Appeal is continuation of the same.
जी.
How a law which is legislative incompetence because of not being a constitutional provision that can be provided by a simple lawmaking power of the legislator.
I have extensively dealt, अगर आप मेरा नोट देख लीजिएगा उसमें, I just want to, क्योंकि बहुत वक्त हो गया है, अगर आप अलाउ करें मैं जरा
सिंपल बता दें आप।
It's your jerky motions that distracts judges. They don't get to concentrate on your arguments.
Sir, there is no bar under Article 184(3) that it bars that you can't create an inter-court appeal, and that has been done in other laws also. I mentioned 2 laws, the Law Reforms Ordinance, Constitutional Forum, appeal is provided.
That is an entirely different premises.
No, my lord, I think it is clearly, and that is what, when I had read the judgment,
it has been explained by Mr. Ijazul Hasan, and very thoroughly that has been explained.
My lord, I would beg to disagree. And then, of course, there is the appeal in the contempt of court orders. But now I'll come to the most difficult part, and with the utmost respect to the benches, which is
incidentally for the third time you have said, I now come to the most difficult part. So
you're moving stepwise.
Every section of this law is so convoluted and difficult that
I have stated the reason why the law is so difficult.
Every section is the most difficult part of your argument.
The most difficult part is that one never wants to say that, Your Lordship, there is a judgment which should be revisited. There are two judgments, and they have been rightly cited by the petitioner's counsel, my lord. One is the Bas Kakar case, where they have relied on certain principles of law and constitutional principles on the basis of which they seek the striking down of law. I will not go into the detail of this judgment, my lord. I'll just point out the pages. Page 1993 to 1995 deals with section 8 of the Contempt of Court Act 2012.
ये कौन सा पास मोहम्मद वाला है?
जी, PLD 2012 Supreme Court 923.
923.
Now, my lord,
इसमें कौन बताइए?
Sir, 993 to 995.
993 to 995 इसमें क्या खराबी है?
Sir, section 8 in the Contempt of Court Act.
ये कितने जजेस का?
Sir, मेरे ख्याल में 5 दिखाओ बेटा, 5 member.
देना इधर एक
1 2 3 4 5 थे सर.
अच्छा, इसमें ये पेजेस गलत हैं, क्यों?
नहीं, ये पेजेस गलत नहीं है, distinguishable है. The reason is that if your lordships looked at section 8, which was struck down, of the Contempt of Court Act 2012, which I have attached in my notebook, वो ये करता था कि एक जज ने कॉग्निसेंस ले लिया है एक कंटेम्प्ट का, और वो ये कहता था कि ये ट्रांसफर कर दें. चीफ जस्टिस ने कॉग्निसेंस ले लिया और कहता था ट्रांसफर कर दें. So it was really interfering in judicial orders. Now, when it came to the appeal, what the Supreme Court has done is that it has said that section 19 में जो appeal है वो ठीक है. Those are pages 1000. Those are pages. वो दिखाना मुझे judgment दिखाना. It's para 82.
पैरा 82 ठीक है, पैरा 82 ठीक है, कोई फर्क नहीं पड़ता है.
एक मिनट,
पेज बता रहे,
पेज नाम बताइए.
1004
ठीक है, पैरा 82 हो गया, हम ढूंढ लेंगे.
पैरा 82, and after striking down the 2012 Act, that law is revived. Now, the problem with the appellate appeals provision in the 2012 law was कि सर उसमें लिखा हुआ था एक अपील फाइल होगी, वो किसी शो कॉज के खिलाफ, हर किसी के खिलाफ, और फिर फुल कोर्ट बैठे, सारे जजेस बैठेंगे. मतलब सारा पावर ऑफ कॉन्स्टिट्यूशन ऑफ बेंचेस ले लिया गया था, और उसमें लिखा था फौरन सस्पेंड हो जाएगी. So that was such an interference that though whatever has been said,
no, but can't you reconcile it by simply saying that in that case the parliament did something so extreme,
yes,
to protect people of a particular who have been may have committed contempt, therefore the court found it necessary to intervene. Here maybe they have not done something so extreme.
And the law was, I think, unconstitutional. So वो distinguishable है, provisions देख लीजिएगा. Now I come to the judgment which, with due respect, I think if the law is to be upheld, this law has to be revisited to a certain extent. If your lordship may kindly see,
judgment है?
Sir, this is called the Ghulam Mohyuddin case.
Citation देते हैं.
Sir, ये unreported है. It is 11th August 2023.
11th August, ये कितने member bench है?
Three member bench. नहीं, this is constitutional petition number 21, 22, 23 of 20. मैंने लगाया है सर अपनी पेपर बुक.
ये कहीं रिव्यू वगैरह में तो नहीं पड़ा हुआ है?
Sir, this is in review also.
रिव्यू में फैसला हुआ है?
नहीं.
तो फिर इसको पता नहीं मुनासिब है या नहीं बात करना है इसके मुताबिक.
Sir, there are passages in this
तो
judgment.
अगर इसमें देखिए, अगर हम फिर उसको रिव्यू को फिर रिडंडेंट बना देंगे.
Sir, वो बात, I think even if those passages are revisited, the judgment on its own would stand.
नहीं देखिए,
But there are passages.
नहीं फैसल सिद्दीकी साहब, दो बातें हैं. पहली बुनियादी बात है, अगर एक वो रेगुलर उसमें आया है हमारे पास रिव्यू में, जो राइट एक्सरसाइज है, उसको हमें बात नहीं करना चाहिए। अब जहाँ तक असूल की बात है, अगर हमने इस केस में जिस तरीके से भी फैसला किया, असूली फैसला किया, अब उसका शायद असर उस पर पड़े या ना पड़े वो तो एक अलग बात है, क्योंकि लार्जर नहीं, वो हम देखें उधर जाने नहीं चाहते हैं, तो इस केस का जिक्र ही ना करें बेहतर।
My last point and then I will conclude, sir. Page 8.
One thing I need to add. This law, which is under challenge now, was promulgated on the 21st of April 2023.
जी
or review of judgments law immediately after that, which is 26th of May 2023. And if you go through, compare both laws, they are a repeat of each other almost, except that in review they said कि जी review में वही grounds होंगी जो appeal में होंगी. And it was pointed out to the.
सर वो पोएम थी ना, try again वो.
उसका क्या बना?
Okay, you answered that.
उसका केस
You answered my question. Try again. There was so much desperation.
नहीं, वो सेटिस्फाइड हो गया
जी?
उसमें भी रिव्यू है या नहीं है?
नहीं, ये वाला रिव्यू वाला तो
नहीं, ये जो दूसरा
नहीं, ये उसी की बात कर,
उसमें भी रिव्यू हुआ है या नहीं?
जी नहीं सर, उसी की बात कर रहे हैं, उसी की बात की।
इसी में
जी
तो अच्छा ओके।
आई थॉट एक और केस हुआ
जी
ये सब्सिक्वेंटली आया।
सर लास्ट पॉइंट which is page 8 of my note.
Whether last point is difficult or easy?
नहीं सर, ये सबसे आसान है. This might actually unite the court. Sir, if your lordship comes to the conclusion that any part of this law, let's say section 3,
don't throw the baby out with the bath water.
Sir, ये सारी जो प्रोविजंस अगर आप देखेंगे तो इंडिपेंडेंट है, सिर्फ 3 और 4 का ताल्लुक है 2 से, और किसी का ताल्लुक नहीं है. 3 और 4 refers to the committee in section 2. Even section 2, if it's upheld and section 3 and 4 are not upheld, it will not make a matter. So if your lordship comes to the conclusion, I hope your lordships and ladyships don't, but then the doctrine of severability can be applied in this case. It couldn't have been applied in the 2012 case. I'm very grateful to your lordship for a very patient hearing, to all your lordships and to your ladyships.
Thank you. At least speaking for myself, I compliment you for answering or trying to answer all the questions to the best of your ability.
Thank you,
were well prepared.
Thank you, sir.
I'll add my voice to that.
You must thank us also. We made you exercise, lose calories.
Thank you, sir. Thank you. Very kind, sir.
अब कितने लोग रह गए बता दें कौन कौन से हैं? कोई जो